Namaste and a very warm welcome to TIL Legal Tips, Episode 5. I am Sushila Ram Varma, Chief Consultant at the Indian Lawyer and AlliedServices. Today I bring to you a very important and very interesting topic called arbitration. The first question that would arise is, what is arbitration? Arbitration is a means of resolving your dispute outside a court of law. It is also known as an alternative dispute resolution process. It is like a private court where the parties appoint a person to act as the judge, namely the arbitrator, who will look into the issues between the parties and decide the same in accordance with law. The second question that would come to one's mind is, can anyone invoke an arbitration if they want to resolve their disputes? The answer is yes, anyone can invoke arbitration provided they have an arbitration agreement in which it is stated that both parties will resolve their disputes by arbitration. The next question, which would be a sequel to the second one, is, can a party without an arbitration agreement go for arbitration? Again, the answer would be in the affirmative. Yes, you can go for arbitration without an arbitration agreement if you write to the side with whom you are having some issues that you would like to resolve the dispute with arbitration. If the other side agrees to do so, then both parties can jointly appoint an arbitrator who can resolve the dispute through the process of arbitration. Another question would be, can a party go for arbitration if the opposite party refuses to appoint an arbitrator? The answer is very simple. Yes, you can. You have to approach a court of law under Section 11 of the Arbitration and Conciliation Act 1996, by which the court will take cognizance of the fact that you are interested in appointing an arbitrator, and the court will assist you by inviting the opposite party, and both parties will be asked to appoint an arbitrator. Sometimes the arbitrator can be suggested by a court, otherwise the option is left to the parties. Another important question is, what are the steps that have to be followed in an arbitration? The party that invokes the arbitration generally initiates the arbitration by filing a statement of claim or a claim petition regarding the dispute and how the party is entitled to certain reliefs. This is followed by the opposite side filing their reply, and the party again gets an option to file a rejoinder. There may be interim applications in between in which the parties seek some interim reliefs. Once the pleadings are complete, then the trial begins, which is very similar to what happens in a court of law. Both sides lead the evidence and the witnesses are cross-examined by the opposite party, after which both sides will argue the matter, and the arbitrator, after hearing both parties, decides the case by passing an award. Another very important aspect that must be looked into is whether an arbitral award is enforceable. The answer, yes, it is enforceable as if it were a decree of the court. The next question is, does the party that has lost the arbitration have an appeal mechanism? Yes, the answer is, you can go to court and file your objections under Section 34 of the Arbitration Act, in which you will put your reasoning as to why the award should be set aside. As this chapter on arbitration is very important and cannot be dealt in one episode, the next episode will carry questions on how an arbitral award can be enforced or how it can be objected to. Dear viewers, if you like this video, please like, share and subscribe. It can be very encouraging to get good comments, and we would definitely want to increase our subscribers so that we can share legal tips with as many people as we can. Thank you.